Thank you, Mr. Chairman. I've listened with interest to the hearing thus far, and I think one of the things that seems to be at play is that this is a question that requires some balance. And I think the panelists as a whole, I'm not sure we're getting all of the perspectives that are at hand. Let me explore it just a little bit. Mr. Weiss, I'm going to pick on you just a little bit, sir. I appreciate, by the way, there's no love lost by me for your nemesis, Amazon. It is operated by one of the most generous far left donors in politics. But I pulled it, and I celebrate, sure, your success in creating a business. I pulled up your website though, and you've got terms and conditions there. They don't contain an arbitration clause, but they do have provisions. There's a provision, the forum selection clause, that would require somebody using your site to bring their lawsuit in a Massachusetts federal or state court. There's a contractual limitations period requiring them to bring their lawsuit within a year. You've got disclaimers of warranties in order to limit your liability. You're not trying to abuse consumers in having those sorts of provisions in your terms and conditions, are you, sir?
No, of course not.
And I think if you were susceptible to being sued in state or federal court in 50 states, would that make it harder for you to be able to survive as a startup business, building your enterprise?
Look, I'm not an attorney, so I'm not exactly sure, if how it would play out. So I don't exactly know how to answer that question. But to your point, we're set up to do business and try to service our consumers and try to offer the best service. And hopefully we never have to be sued. We don't have arbitration. We haven't been sued a lot. We have been sued not by consumers, primarily, collections partners and stuff like that. But we're clearly, in business to try to offer a service and a product for our consumers. That's what our focus is.
And Mr. Weiss, obviously you're building something that people value. And I'm sorry, as I said, I sort of have to pick on you, because the point is, many times if you're a consumer to Amazon, but you're a seller to others, and so the utility of some of these things, I think, can get lost when people are focusing on highly emotional, just on one side. And so as I said, sir, I didn't mean to pick on you, because I think we need to celebrate people who are building businesses that serve us all. And I think it's important for us to reflect on the fact that, take the nursing home example Mr. Deutsch used, how many people would be harmed if there were no nursing home, because the risk environment were such that the business couldn't exist? And so there's great utility, arbitration agreements. I've been litigating with arbitration agreements for 30 years. And I've seen some situations in which I didn't think it was great, but I think you have to proceed with great caution when you're throwing all this to the wind. There's a risk of throwing the baby out with the bathwater. And I wonder, Mr. King, just on that perspective, I'd ask you if you have any comment on the point I just made that you'd like to offer in my time remaining.
Absolutely. The disruption factor for millions of individuals that do use arbitration, businesses that use them, would be tremendous, particularly if the FAIR Act is construed to be retroactive. I just want to share a figure. As of September 30th, there were more than 650,000 cases pending in our federal district courts. Now, the nursing home example, the presumption is if you took those cases to arbitration, the claimants would be treated unfairly. How do you know that? You don't know that. In fact, they may receive even more money. See, that's the presumption we're dealing with here. People presume that they're not going to get a fair deal in arbitration, yet they have no experience with it, or they make assumptions that are not supported by facts. Claimants do better in arbitration. So I would suggest to you, in the arbitration setting for nursing homes or other situations, arbitration can and will work. We can take secrecy out of it. I've already addressed that. That's a misnomer. That's a red herring. Secrecy and mandatory arbitration are not one and the same. In Ms. Carlson's situation, it's a perfect example. Yes, I know of your clause. I read it carefully. I know a lot about your case. The fact is, you were able, notwithstanding that case, to publicize your situation throughout the world. In this day and age we live in the platform economy, and the ability to instantly communicate, people know if they're being treated fairly or not. So to suggest that you were muzzled, of course, is incorrect. We know that's not the facts. We need to get people involved in litigating disputes in a way that makes sense, is less costly, more efficient, and more expeditious. And alternative dispute resolution procedures and arbitration are the way to go.
The gentleman's